Stella Tsai, Democrat for Pennsylvania's Commonwealth Court. Why are you running for this office?
That's a great question. A good one to kick things off. So it's been my great honor to serve as a judge of the Court of Common Pleas for the last 8 years. And I am well aware that the Commonwealth Court weighs in on some of the most important issues of our day, public education, voting rights, free and fair elections, the environment, you name it. And I also know it's also a court of last resort for some litigants. And when I learned that there's a vacancy on the court, and given my background, which I think we're going to be getting into, you'll understand that it was almost imperative for me after I reflected on a few minutes that I run for this seat of the Commonwealth Court.
And how does Commonwealth Court fit within our legal system?
Okay, that's a good question. I sometimes have a chart with me, but I don't have it today. But I'll just explain. If you think of the court as a pyramid, you have the magisterial courts at the bottom rung, then you have the Common Pleas courts on the second rung, and then there are two appellate courts which sit above the Court of Common Pleas. One is the Superior Court, which my colleague Brandon Newman is running for, and then there's the Commonwealth Court. Commonwealth Court was established in 1968 to address the appeals that deal with government agencies and state and local governments. And that's why it addresses some of the larger issues of our day that affect Pennsylvanians across the Commonwealth.
How busy is Commonwealth Court, especially compared to the court that you're currently serving on?
That's another good question. I think it's a very busy court, as I understand it. I think it issues, quantitatively 1,000 opinions a year. There are 9 judges serve on that court. I serve in Orphans Court right now. I can't even count how many cases I've been dealing with. I have a lot of matters dealing with trusts and estates and guardianships. But I would say that the workload is different but comparable in terms of volume. And I have to also add that the Commonwealth Court serves as a trial court in addition to an appellate court from the Court of Common Pleas. And it will hear matters involving the Commonwealth, whether it's a plaintiff or as a defendant. And occasionally those matters involve preliminary injunction hearings, which is a period of time, very, very short, brief matter where somebody believes that if something relief isn't granted, there will be some sort of irreparable harm. They have to establish that in order to get that relief. And those hearings are often assigned to the judges of the Commonwealth Court at the trial level. And those are things I have enjoyed, for lack of a better word, since I was first started practicing law. It's a tense period of time. I fortunately am in a position in my life now where our kids are grown and doing other things now. And so I just have, and my husband's about to retire, so we have the wherewithal for me to devote the time necessary to handle that type of work.
So, Judge, tell me more about how things contrast between the court you're on now and the court you're aspiring to, Commonwealth Court.
Okay. Well, I actually handle some matters that go up to the Commonwealth Court. I sit as a judge in Orphans Court, but in the past have served in election court where I dealt with issues, whether petitions for people trying to get on the ballot, become candidates, or also when there are matters during day of election where we have questions raised by one of the parties or other about concerns about how the elections operate. I will then draft opinion, and then that gets considered if it's appealed to the Commonwealth Court. And I would say that a lot of the work that I do now is in a different realm. It's in those matters go up to the Superior Court as opposed to the Commonwealth Court. But a lot of my experience from when I was practicing law was related to government agencies. So that's where I get a lot of my background.
Let's talk about the characteristics of a good judge in general. Yeah. In your opinion, what does it take?
Well, I think it's a given that you have to be fair and impartial, but I think temperament's something that I like to talk about because it's one of those situations where I believe that my years of practice made it a little easier transition for me into a judicial position because I think I have a lot of life experience in addition to work experience. And pretty much, I don't say I've seen it all, but I've seen a lot of things. And I think I have a lot of patience. I have a long fuse. And it's important because I have to manage the parties in the courtroom, because if we don't have dialogue and it's more like a battle, you can't get a good record, and without the record, you don't have a proceeding and something that will document what happened. And I also think when I had juries, I used to be in civil court, civil division or trial division, and I would have jury trials, and you need to be able to communicate information, impart what the testimony is to the jurors so they understand what's going on. And if you have a courtroom that's sort of chaotic, it does not serve anybody's purpose. So I have made sure that my staff and I maintain good control of the courtroom so that everybody can hear what's going on and they understand what's at stake.
Now, a minute ago, you did mention judicial temperament, and you said that you have a long fuse. Can you give me an example of a situation without providing us names, of course?
Sure. I would say that I don't get angry easily as a personality trait of mine. But I also recognize that the parties, sometimes this is a very serious situation for them, and they are being put on the stand, and sometimes they're frustrated and they act out occasionally. And I don't take those things personally, because I recognize that they are not necessarily directing their ire at me, the court, or the judge, but actually just the whole process. And I try to make sure that they are in a position where they feel comfortable and confident in the validity of what we're doing, so that they don't feel they're under attack and that they can just tell their story. And I think that's really important for us to be able to encourage the litigants to feel that they can just tell their story without having to resort to fisticuffs like they used to in the old days, before we had the judicial system.
Now, in addition to judicial temperament, which is something we often talk about in these candidate interviews, there's another phrase that comes up periodically, and that is judicial philosophy. Is that the same thing as temperament, or what does that mean to you when that phrase comes up?
I think that there are judicial philosophies that are practiced by people at places like and I will just leave the United States Supreme Court as opposed to Pennsylvania Supreme Court, where they may have a particular perspective on how a constitution should be interpreted. And our job as a trial judge, and to some extent at the Commonwealth Court level, we are required to apply the law and the facts as we see them. And I think that Justice Ketanji Brown Jackson did talk about her judicial philosophy. It's more of an approach as opposed to her MO, which I think is an appropriate one, which is like and this is not a philosophy, but how we make sure that we decide things fairly and impartially, like we're supposed to under our constitutional responsibilities. One is you kind of just recognize that you need to sit back and not have any biases, which is something we try very hard to do, but it does take some work, because I think you come to anybody, a fact find, I say this to our jurors, we all come to this with some implicit biases, and I hope that's not a bad word. I think it's a good, we just have to recognize that we sometimes look at people a certain way and impute certain characteristics to them, which may or may not be fair. And I think I even one real quick situation where I came upon construction workers, and what I would expect them to be listening to was not what I heard, which was NPR. And so, we often try to associate certain characteristics with certain people, and I really encourage the jurors and myself to try to flush those biases.
You might have preconceptions about somebody that might not be right.
People, right. Just try our hardest to do that. I will also, when I hear testimony, sometimes try to catch myself making sure that I articulate what it is I'm thinking. And I want to make sure that when I have parties, and I do, Philadelphia, while it's a big city, you certainly know people. And I tend to, when I happen to be acquainted with a litigant, I will disclose that on the record to make sure that nobody has any objections to it, and we're step aside, and so that they can make their call. But I do want to make sure it's not the person that I'm, in front of me that I'm really assessing here, but what comes out of their mouth, what they're testifying to. And I have to say that during COVID, it was particularly enlightening to me because I think that everybody was wearing masks in Philadelphia. I don't know what the other protocols were. And we really had good mic systems so people could hear what was being said. And I kind of appreciated that because we did not then, we just heard the testimony, maybe a little bit about the delivery, but also we were able to hear the testimony without having to associate them with certain facial gestures that people may misinterpret. And so I think it was very, very useful to have that exercise. And while I think some people were concerned about the use of masks during that time frame, I felt that it really was a good way to filter our own biases. And that was very important to me. And then I find the facts and then apply the law. And that's what my job is. So that's my philosophy.
Like many judges, you used to be a litigator in
Yes.
Philadelphia. So tell us about those days and what kinds of cases you worked on back then.
Well, when I first started practice, I did a lot of cases involving civil RICO, which is the Racketeering Influence Corruptions Act, signed by President Nixon, and many, many years ago. And it was involved racketeering, but in the civil context, not in the criminal context, where businesses would allegedly conspire to somehow deprive somebody of something, and those are the kind of cases I handled, and they were kind of exciting because the case law was being developed at the time. My first case that I tried in court was a preliminary injunction hearing involving car polish commercials, and there's a question as to whether there's some copyright or trademark violations. That was kind of fun, although I guess you're in this industry. I am a big fan of television, but I did not, and also I enjoy a good show once in a while. But you realize that when it becomes work, it's not as it's just work. It's work, right? So you have to compare these two, see these things over and over again. But then I became a lawyer in insurance coverage litigation, and where a lot of cases were huge stakes. These are cases involving environmental insurance demands made by big companies who have been accused of polluting. The question is whether their policies covered those types of cases, but those cases never resulted in any litigation except for summary judgment. If you get lucky, if you got to argue one of those. So I then went to the city law department and supervised the lawyers who handled those cases in court, environment, obviously it's not environment, and employment and labor, then also social welfare agencies. After I finished that tenure at the city law department, I did serve on the Civil Service Commission, but I also decided I was going to, for one, at least finally become a real trial lawyer. So I took one of those courses, and then next thing you know, I get the opportunity of a lifetime, which is to litigate a case against SEPTA on behalf of the city of Philadelphia. And are you from the Philadelphia area?
I'm not. We're in Camp Hill near Harrisburg. So
Okay.
For our viewers statewide, fill us in on some details.
Okay, so at the time, so Philadelphia, we have SEPTA, which is the Southeast, Philadelphia Transportation Agency, and we have the cards to go from place to place. But at the time, we had either tickets or passes for certain people who could afford them. But we also had paper transfers, which are the things you use to go from system to system. Philadelphia is, I learned a lot about transportation during this, but we are a system in Philadelphia that is composed of several different transportation forms, which were collected into this agency. So they came from different systems, but they combined into one transportation system. And people could buy for 75 cents a paper transfer, allow them to move from system to system, because you kind of need to get from one place to the other. And SEPTA had decided to eliminate that paper transfer and force people to pay fares each time they transferred, which actually would end up hurting or penalizing the people who could afford it least, because other people cannot afford the pass that might get them from place to place. And so we filed a lawsuit, and it was a situation where we were able to persuade the judge, it was a judge trial, that that was a manifest and flagrant abuse of SEPTA's discretion to adopt a plan that would force the least able to afford it, force those, the cost onto them. So that was a very exhilarating case. I mean, I guess it's exhilarating because we prevailed, for one thing, but it is a lot. That type of litigation can be a lot of fun, and we tapped on a lot of experts that worked within the city agencies, and it was just, again, another understanding how profoundly talented our people are that work within the city agencies, and that we were able to draw on their expertise to help develop our case. It was just a really, really great opportunity. And then, since then, I mean, I did do a lot of pro bono work, represented one gentleman who was a Chinese refugee who landed on Rockaway Harbor in New York and was incarcerated in York County Prison because they had space, along with several others. And we pursued an asylum case for him. And 10 years later, we were successful in getting him asylum, but it took a long time. Fortunately, we were able to get him into the community because we were able to persuade the court that he had entered the country and thus entitled to have at least some sort of bail, and that he was allowed to leave the facility. But it was a long journey. But I also handled a lot of other matters, including election court and did some advocacy too, on behalf of those who are trying to oppose photo voter ID. So those are the things that sort of make up who I am.
Yeah, can you give us the details of any case that involved safeguarding voter rights, again, without supplying names?
Yeah, well, so there are several things that I've done. One is I sometimes would represent parties or sometimes individual voters on election day if there were issue at the polls. And one case I remember in particular where we were asked to protect the ability of voters who had ended up in what facility? It was a rehabilitation facility who were stuck there. And at the time, we did not have Act 77, which allows mail-in voting, but there were very narrow circumstances upon which you could use an absentee ballot or vote that day.
Right.
And the documentation that they provided to allow these people to vote, I think was signed by a doctor, but may not have been. There's just one little very technical issue that stood between these people and whose party I did not know.
I see.
And voting. And at the time, we certainly represent the Democratic Party. We did not look at registration, did not look where they came from, but just thought it's just important to make sure people exercise their franchise. So we litigated that, and we're successful at the trial level. We got the election court judge to authorize them to proceed to vote. But that particular decision was appealed to the Commonwealth Court, and we persuaded the Commonwealth Court that it was appropriate for them to vote, these people in rehab. So those are the kind of things I would work on.
Well, Judge, let's take a step back then. How big a problem in general is Philadelphia voter disenfranchisement in a general sense? How big a deal is it?
That's a good, well, if you talk to the officials, especially Al Schmidt, who oversaw our last election, it is not endemic. It's not part of our system. Occasionally things happen, and they get prosecuted. But I would say, and I actually did decide a matter involved in 2020, involving how far individuals could stand when they were observing the processing of the mail-in votes. And it was called in-rate canvassing observation. I don't know if you remember that case. But
what was the issue there, Judge? Were the observers getting too close?
The observers wanted to get closer. So that's why it came to us. We had it was an evening, at most 10 o'clock, when the election court was supposed to close, and the Trump campaign decided to bring an action at that time, and we stayed till it was over. But it involved how far the observers could stand from those processing ballots, and my judgment was that certainly the legislation itself, or the act itself, did not require any specific dimensions. Just that it was what they were allowed to observe. if they're allowed to observe, they fulfill their duties. And the Trump campaign's position was that they had to have what they called reasonable access, or some rubric that was not part of the statute. And the person who testified on their behalf, if I recall, this is 2020, so it's a few years ago. My recollection is the testimony was that I think filled about 10 to 15 pages, and I guess I'm maybe exaggerating, but this person was able to observe a lot of how everything was proceeding. The only thing I remember him not being able to see were the markings on the ballots. And that, to me, is not something that it's certainly fair game for an observer to be looking at. And we decided that what was appropriate. And I did have a coda on that particular statement, saying do whatever you can to make it more accessible, but it was accessible the way it was. That decision, which I thought was pretty straightforward, did get appealed to the Commonwealth Court, which I think the next day, within a few hours, reversed my decision and said that it had to be 6 feet. I was a dutiful judge. I adopted that, incorporated that in my order. But while the case continued to proceed to Supreme Court, because it's one of those decisions that might evade review if you don't deal with it now. So the parties took it up to the Supreme Court of Pennsylvania. Supreme Court of Pennsylvania reinstated my trial order, but it was a little later.
Well, Judge, let's turn away from your experiences in the courtroom as a lawyer or a judge and consider your activity in the classroom, specifically at University of Pennsylvania, adjunct professor. And tell me about the experience there and the impression you're trying to make on students.
So it's a class where we talk about remedies. And remedies is essentially what you get if you win. So it's a really basic definition. And what we do in this class is we take them through different courts and different types of rights and what is a remedy to the right. And I have a couple areas of responsibility, and then we kind of look at the headlines and also to occasionally grab things and talk about those issues. But I will have, for the past few years, put on a trial so that the lawyers to be, the students can serve as jurors and to see how it works and under jury instructions are delivered and understand how the case goes. And it's a case that actually did take place in my court, which was, it's a transcript drawn from life, where a plaintiff who happened to be hearing impaired was involved in an accident, not caused by SEPTA, but by a third party who had, it ended up causing an accident. And through that, the plaintiff's ulnar nerve was damaged. That's the causation, and that's something for the fact finder to do. As a judge, I kind of have to I'm just relaying what the findings were. And so ultimately, that person who spoke with, used her language, was with her hands, and she could not speak as well and was impaired. And so the jury, and I could tell you what the verdict was, which is sort of a little higher than I think most people would have predicted, was $750,000. And that's a case that we then took to the students. And each year it's kind of interesting to see how the verdicts are vary. But we do things like that. We also talk about national injunctions. It's the federal case. I teach it with a federal judge and a former attorney from the ACLU who's now in private practice. So we get to a lot of meaty issues, and it's been really, really gratifying experience for me.
Judge, we only have a few minutes left. I want to make sure we get to, we only have a few minutes left, and I want to make sure we get to the PA Bar Association's rating systems for candidates. Now, they awarded you a highly recommended rating, and tell me briefly about the process, how you participated in it, what value you think it has for the public.
I like to think it has a lot of value, but I will just tell you that it is a very vigorous and very process where they have you complete a questionnaire, which is I don't say 100, but many pages long with many questions about everything you've ever done. They ask about your background and what you've, well, if you've done anything or have had any issues with your practice, and also as judges, what kind of cases you've had. And then they have a team of investigators who then follow up on what you represent on the pages to confirm or to, confirm, I hope mostly, what you have stated in your papers, and to talk to people about your reputation and what you've been able to accomplish over these years. And so through the process, we then, after that investigation team publishes a report, they then turn it over to the panel, and then you present yourself to the panel and they ask you questions about what they review. And so through that process, I was able to obtain a highly recommended rating, which I'm very grateful for.
Let's talk about your campaign, Judge. How do you go about it? Sometimes it's a challenge for someone running for judge here in Pennsylvania because you're not allowed to talk about the issues. So what do you talk about when you communicate with voters?
Well, I talk about our rights. And also, just so you know, I happen to be a member of the Pennsylvania Judicial Ethics Advisory Board. So I have some understanding of how our code works. And there is a perception that we can't talk, and I'm not inviting you to ask me about specific issues, but we cannot commit to certain positions. We cannot commit to how I would rule in a specific case.
Right.
That would make it, I would be forecasting what I'm doing, and I can't do that. And perhaps if you can forecast who I am through what I've done, I can talk about my past work. I can also talk about cases and values, and which and I certainly, through my campaign, have talked a lot about how important democracy is to me. And if I could just speak a little bit about that issue. My parents are here, but came here leaving Taiwan at a time it was controlled by a pretty repressive and dictatorial regime. I was born in America and in Harrisburg, and had some encounters with that government when I visited Taiwan as a child, being told to be quiet because they were afraid what we were saying would be reported by their neighbors to the authorities. That was very chilling to me as an American kid. And I can tell you as a child, I certainly had developed a deep appreciation for our democracy and our right to speech, who we are as a people, and right free of association. And I've never taken that for granted. And that's one of the reasons that I found it very important for me to step up and run for this office, because that's part of the job, is to protect people's rights.
Judge, we only have about 30 seconds left in our program. Use that time, please, and tell our viewers why they should vote for you in May's primary.
So I could like to tell the public that I can assure you that this judge will continue to work tirelessly for you, and I will issue decisions without fear or favor.
Stella Tsai, Democrat for Pennsylvania's Commonwealth Court, thank you for your time.
Thank you for this opportunity.